Good afternoon, everybody. My name is Chris Justice. I'm an associate lawyer with Samfiru Tumarkin, and I'm here today, as always, to hopefully answer as many questions as possible, all things related employment law. So if you've got a question, perhaps about a contract that you've been presented with, or maybe you're going through some issues within the workplace itself, or possibly as well, you might have lost your job recently or been placed on a layoff and you have some questions, get them in today, and I'll do my best as always to answer those questions during the time allotted. But as I always do as well, I want to start with a topic off the top. This time it's going to be relating to social media in the workplace. Obviously, many of you have social media, and sometimes what you post on social media can affect your job in some way or another. So the first thing I wanted to highlight off the top was that anything you post online, whether you think it's under certain privacy settings or not, can and potentially will be seen in a more public fashion and be seen by your employer. So don't always assume that it can't be seen by others. Even if your boss or your manager can't see something that you post on social media, others may, and those people may relay that information to your boss or manager themselves. This can also apply to things like text messages. A lot of times those can find their way into the hands of the company. So again, depending on what's in these messages or in these posts, there could be repercussions if your boss, for instance, becomes aware, even again, if you didn't want them to know about it. As far as the company itself, in terms of social media, they should always generally have a social media policy in place that sets out what is allowed and what is not allowed in the workplace. It can't be just some piece of paper or binder that they gave you 10 years ago that's locked away in some drawer. It's usually got to be a policy that the employer reminds their employees about on an ongoing basis, maybe updates the policies themselves. And the employer generally has to reinforce this policy every once in a while. Like I say, not waiting 5 or 10 years to sort of refresh the employees. So they can't forget. That's not going to be effective. And if the employer is going to try to punish somebody or let somebody go due to a breach of a certain policy, then it needs to be communicated well beforehand. It needs to be clear as far as what's told to the employees. And so if there's not something that's in place there, it's going to be harder for the employer to allege any sort of breach of policy or use that as leverage to ultimately get what it wants. But as an employee yourself, you want to make sure that you've read it, that you've understood it. And of course, if you have any questions, try to get some clarity from the employer. That said, though, another thing in the policy that it should address has to do with protecting the workers, employees from harassment or bullying, and that can include through online conduct from their peers. So you might be in a particular social media group or chat group, and you might be getting some form of cyberbullying or some bullying online from another coworker, and your employer, just like in any normal harassment or bullying situation, needs to ensure that that kind of stuff is eliminated. And again, there needs to be a policy in place to deal with that stuff. So that can very much apply to the online space. And if your employer catches wind or gets informed that you may have been subjected to some online bullying or cyberbullying, and they don't investigate the situation or they don't look into it, and basically they drop the ball, then that could be illegal potentially. That could be a constructive dismissal, and that may allow you to treat that as though your employment has been terminated and go after the company for full severance, and even in some cases for additional damages as far as human rights, depending on the nature of the complaint or the harassment that you're going through. But you can nonetheless, like I say, be punished for your behavior on social media. So I started off by saying that you should always assume what you post is going to be seen by others. And so if you say something that or do something online that reflects poorly or bad on your company, the company can penalize you. So again, regardless of any privacy settings, you want to be mindful of that. And ultimately, you just don't want to be in that position if your employer does to take some form of disciplinary action or punishment towards you. Having said that, though, and as a final piece just on the social media front topic, most of the time, as many out there probably know, it's going to be very difficult for your employer to say that it has just cause to terminate your employment. A lot of times people can be let go essentially for any reason whatsoever, even if it is for a breach of a social media policy. So in that sense, practically speaking, you may lose your job if your employer finds out about something and doesn't like it and decides to let you go for that reason. But you're still going to be entitled to your full severance in most cases. So a lot of times employers will try to say that they have cause to terminate your employment. And when they let you go, basically give you nothing on your way out. And this could also extend to the social media policy breach scenario. So if you've, again, said something bad or disparaging arguably towards your employer on some social media platform, does it mean they can discipline you? Yes. But to say that leads or amounts to just cause at law is probably taking it a step too far. Fact is that it's very, very difficult in general for employers to establish just cause. So frankly, even if you did say or do something bad, let's say on social media that your employer finds out, the chance that that's going to rise to the level of a just cause dismissal, it's going to be very rare. And even in these instances, even if you've done something, you're still likely going to be looking at your full severance. So either way, whether they try to make out a just cause case or they maybe give you a severance package, but you're thinking it might be a bit light, you definitely want to give us a call, get in touch with us as far as just figuring out, what are my options? Because as many, again, know on here, you could get potentially upwards of 24 months of severance. So it's not something that you want to sort of take lightly. But with that said, I'll get into some of the questions. I'll go back to some other topics that I can speak about in general, but let me just answer a few of the questions that have popped up. So I've got one in from Asher on YouTube who's saying that they've just accepted a new position and the contract includes a non-compete, so a clause regarding non-competition. And Asher's research tells them that this is not legal. Does this make the contract void, or do I have to accept this and now honor it? So if you're in Ontario specifically, Ontario essentially banned non-competition clauses. So if you were to sign a contract this year or last year, and in that contract, even signing it, there was some section dealing with a non-competition clause that says something along the lines of, if we ever let you go or you leave our environment, you can't compete for, this group of people for a certain time frame, maybe within a certain geography. That's going to be deemed basically illegal from the outset, even if you have signed it. So nowadays, if you sign a contract that has a non-compete, it's pretty much a certainty, if not a certainty, that the company will never be able to rely on that non-compete to prevent you from going out and seeking new work, for instance. If you're somebody who has signed a contract with a non-competition clause maybe 5-10 years ago or even further back, then the likelihood is still that non-compete won't be upheld by a court. So the odds for you are still looking good, even if you signed an older contract with a non-competition clause in it. But it's just particularly for contracts signed after 2021, they've been banned. So it's essentially not worth the paper that it's written on. But that doesn't make the whole contract void. So you could have like a 10-page contract, 1 page of which deals with non-compete, and that can all be illegal or sort of off to the side. But then there might be other aspects of the contract in the other 9 pages that are valid, that are not illegal, that are not offside with the law in some way. And those parts of the contract can potentially still be upheld. So I just in general will always recommend that regardless of who you are, regardless of whether the contract has a non-compete in it or not, if you're being given a contract, an employment agreement, especially if it's a pretty lengthy, detailed one and not just a 1-pager, you're going to want to make sure that a lawyer reviews it, because the non-compete may not be an issue at all, but there could be those other clauses that you may not even think about that could result in you getting tens of thousands, if not more, less in the event that you were to be let go, for example. So don't think it would necessarily make the whole contract void. don't think that there's any risk realistically of that non-compete being enforced, but could be some red flags or some issues with the contract more generally that you might want to, as I say, have us take a look at and review and get back to you. But thanks for your question, Asher. I've got another one from Fabian, who's saying that they've been given a service dog to help with their condition. Their employer is trying to make it difficult for them to bring the service animal into work, but they're not allowing me to work from home. What are my rights? Can they fire me or for requiring a service animal? So if you have a service dog or an animal and you can show through evidence, maybe doctor's note, records, what have you, that the dog or the animal has been assigned to you in a legitimate fashion for a real condition of yours, and that's sort of the recommendation coming from your treatment providers, then that's going to definitely give you more of a leg to stand on to show that you're not just asking for an animal of any sort. It's particularly connected to a condition, a health-related condition of yours. And when it comes to employees needing accommodations for health-related conditions, especially ones where there's medical evidence backing it up, the employer has to generally do everything it can, or pretty much everything it can, to accommodate that situation. It's very rare that employers get off the hook in terms of accommodating employees when they don't want to. They really have to show that to do so would create a massive issue for the company, whether it's financial or otherwise. But it seems like what Fabian's saying is that they've offered potentially to work from home. So if you can essentially do your job from home and get, treatment or get the service dog and have them be there, then I don't see how, practically speaking, that would be too much for the employer to accommodate. If the employer, or if your job rather, is one that cannot be done at home, then I still think that there's a strong argument to be made that you work in office with the service dog, because it's not going to be a huge imposition on the employer. Even if it does annoy them to some extent, there's still that expectation on them to, do their best when it comes to accommodation. So if they're not going to let you work from home, they're not going to let you bring the dog into the office, you've got legitimate backup for making these accommodation requests, then you could be in a situation there where your employer has basically failed in its obligation to accommodate you. That can result in a constructive dismissal, and that can result in you going after the company essentially for your full severance, plus additional damages for the failure to accommodate. And because it's connected to a health condition, not only would you be looking at severance, you could be potentially looking at human rights damages, as well as other forms of damage on top of that. So to fire you for requiring a service animal would be arguably a breach of human rights legislation, and I think just open up a huge can of worms for the company itself. It's definitely a situation where you'd want to give us a call, just because there's a lot going on in terms of the accommodation, potential termination, working from home arrangement. But it does seem like, on the face of it, you've got a lot of options. And if they do decide to let you go, a lot of potential entitlements there as well. Thanks, Fabian, for your question. I've got another one in from Going on YouTube, who's saying that their employer is trying to claim that the work they do outside of business hours is their property. They've been working on an app in their spare time, and they're now worried about trying to publish it. And they're saying that it's not related to the job at all. Can they claim this work as their property? So it may depend on a contract that you've signed. I know that in a lot of cases where the position involves the development of an app or technology, there can sometimes be areas of a contract that deal with rights to intellectual property, moral rights as well, in terms of, again, property relating to the company that they say is theirs. And a lot of times they do have to connect that app, let's say, or that property to situations where you're using company resources to develop the app. Like if you came into possession of certain technology or proprietary information while you started working there, and then used that to develop an app on your own time, there's a potential that the company could claim the property of that. If it's, on the other hand, an app that you're working on in your spare time, and something that you can or would have done regardless of whether or not you ever worked for this job, So in other words, you don't need any of its own proprietary information or confidential information to work on the app yourself. Then there's going to be a greater chance that you can kind of separate that, because it's not, like you say, on company hours. It's not using information obtained while you're working for the company. And so that way you can better distance yourself from that and have a better chance of claiming ownership of that particular work or that app. Versus, as I said before, if you're doing it on company time, or if you're using company resources to develop it that you wouldn't have been in possession of had you not worked for the company, plus whether or not there's any contractual language, then that might favor more on the side of the employer. So I would give us a call if I were you, just because I'd want to flesh it out a bit more detail. Although I will say as well that your question is somewhat IP related in terms of there's an actual body of law dealing with intellectual property, whether it's patents, trademarks, copyright. And, our firm, of course, specializes in employment matters. So depending on how in depth the question or the situation is, I may also suggest speaking with an employment, or not an employment lawyer, a lawyer that deals specifically when it comes to things like patents, trademarks, copyrights, and just IP issues in general. But from a bird's eye view, that would be my answer to the question, Golan. But thank you very much. I've got another one in from Frank, who says that they've been on long-term disability for 18 months and they have unused vacation time. The company policy says they must use it, but they can't go back. Can I get paid for it, or will I lose that vacation time? So I would say, again, as a starting point, I'd want to look at the contract or the policy to see what it says exactly. Sometimes there are policies that sort of say if you don't use it, you lose it. So you could lose some aspect of vacation depending on the policy. Now, in general, though, regardless of what the policy says, most people are still going to be entitled to vacation pay. So that would be if you're making sometimes it's 4%, 6%, maybe 8%. If you're making $50,000 a year in wages, you should be receiving at least 4 or 6 or 8%, whatever the case is. On top of that is vacation pay using your annual wage number. So when it comes to that aspect, a lot of times people are sort of screwed over a bit when it comes to the vacation pay, and they didn't realize or don't realize that they're not only owed their wages, but they're owed an additional percentage on top of the wages that they worked. So that's just one thing I'd want to highlight. But when it comes for vacation time, that can be a different kettle of fish altogether. So Frank, because you've been on long-term disability for 18 months, there wouldn't be presumably any wages that you would have earned, by working, because you're not working. So you're not going to be able to collect on the vacation pay issue if you haven't earned the wages over that period of time. But again, depending on what the policy says, you might be able to go back and get it. So I would want to look at the policy, maybe get a better understanding of some of the back and forth that you've had with the company. But it's not necessarily the case that you are going to lose it. It would just require a bit more of an analysis in terms of the policy itself and what your rights are. It is possible that employers can sort of allot a certain number of weeks per year and then not give the person those number of weeks if they don't take it later on, say like in a subsequent year. So it'll depend on the policy to some respect, but it does happen a lot. People getting kind of screwed when it comes a bit to the vacation issues. So I think you should give us a call just in general, just to make sure that there's no issue there and whether or not you have a leg to stand on. I've got another question in from Casey, who's asking whether or not an employer can combine vacation and sick days, and if there's a minimum requirement for both. So no, the answer would be no. There is a certain number of vacation days and sick days that are required as a bare minimum. They're sort of in two separate categories. Again, when it comes to vacation time or pay, most often you're looking at usually starting off maybe 2 or 3 weeks of vacation time a year, or 4 or 6% of vacation pay. If you've got maybe 4 or 5 weeks of vacation a year, sometimes you can get that. Then your vacation pay percentage would adjust to 8 or 10%. But normally there's a bare minimum vacation time as well as sick time. So if an employer's trying to combine both, then they could be essentially doing something that's illegal, that's offside with the employment standards legislation. And that could be a big issue. That could give you options in terms of, outstanding vacation pay, outstanding sick days. It could point to there being a breach in a certain policy or a contract you have with the employer that could lead to you getting severance. So it's not just necessarily about the vacation or sick days. It could actually lead to something that's greater, and it may give you an option to get out if that's something that you desire. I got another question in from Aubrey on YouTube, who's saying that they've moved into a new position. They worked in construction, but suffered from a heart attack that meant they couldn't do any physical labor. And the employer is saying that their seniority starts only in the new position and that the other years don't count. So that generally looks off to me. So if you work for a particular company in a certain role, let's say for 5 or 10 years, and then for whatever reason you stay with the company, but you transition into a different role, most of the time, if not always, that prior service should be continued or at least acknowledged. And what you don't want to have happen is signing a contract that says something along the lines that your prior service with the company is not going to be acknowledged, it's going to be waived, and that your seniority is only going to start on the day you start this new job. So you want to make sure that's at least not in there, a contract that sort of specifically excludes the extra time that you worked, because there are certain situations where an employer can put something in a contract that basically canceled out all the previous years. And then if you were to, get let go from your position a year later, instead of being someone who's looked at as an employee with 15, 20 total years, you could be only being looked at as an employee with 1 year. And the severance payout on that is going to be way different than if those, other 5, 10, 15 years were included. It would also somewhat, I think your question, depend on what exactly happened in terms of the switch from the old position to the new position. What period of time, was, in between the starting of the new with the ending of the old, whether there was any disability payments, if you went on disability leave, for example, for a certain period of time before going back and sort of contemplating this new role. It also depends on, or could depend at least on, whether as a result of the heart attack, you are never going to be able to do anything physical ever before, or whether you might only be prevented from doing physical things for a certain period of time. These are just examples of some of the questions that I'd probably ask in a consultation. So I think you should give us a call for sure, just so we can go through all the particulars, and definitely before you sign anything that potentially waives all those prior years of service that you had. I've got just a follow-up, a question from Aubrey, who's asking if construction companies are different when it comes to severance. Seems to be, from Aubrey's perspective, the general consensus, but I've never seen anything that supports that. So yeah, there are certain situations where if you work in the construction industry, there's an aspect of the law that says these particular employees aren't owed severance in the same way that other employees are. That's what one area of the law says in a certain for a certain group of people. But then there's another area of the law that says actually you are owed severance just in the same way that everyone or most people are owed severance, and that construction industries don't matter whatsoever. It'll sort of depend, on how related to construction work your position is, whether it's like a managerial position versus or position with supervisory duties or not. But like I say, there are a select few circumstances where an employer could potentially argue you're not owed severance, but the vast majority of these cases, people coming to me saying, am I not owed severance because I'm a construction employee or I work for a construction company? Vast majority of the time I'm saying, no, you are owed severance. They're saying this, but you've got some arguments over here to support why you're owed severance. And it's not just as simple as saying, if you're in a construction company, you're not owed anything. It again requires delving into the particulars of the position itself and sort of also like whether there's a contract and what that says and all this sort of thing. So Aubrey, I'd say give us a call just so we can go through all this. It seems like there's a lot to discuss, but it does seem like there's a lot of options for you if it comes to it. But yeah, definitely give us a shout. I've got another question in from Rami on YouTube, or Romy, who's saying, or asking rather, is it common for employers to not respond to a demand letter? So just to add some context to this, when I get involved on a file, or a lawyer gets involved on a file and is going after a company, so to speak, for more severance, usually an initial goal is going to be to avoid a lawsuit, avoid litigation. So the goal is to try to initially resolve the case or the matter just through some back and forth, some negotiations. And that typically starts with a demand letter coming from the employee themselves or their lawyer. So I'll typically draft a demand letter setting out the overall position that my client has, obviously putting in a demand in the letter in terms of asking for a more fair severance package. And I'll send it off to the company and put a deadline in the letter. Usually give them maybe a week to respond, or their lawyers to respond. Now, until you actually sue a company, start the litigation process, serve them with papers, there's no way for you to force the employer to respond to your demand letter or to respond at all to any negotiations. So in that sense, the employer could just simply not respond and just hope that you go away. Typically, at least in my experience, when I get involved and I send a demand letter out, I usually receive some form of a substantive reply from the employer within a week or two. Sometimes, like I say, they got to hire an outside law firm to deal with the matter, and then that law firm contacts me and lets me know they're involved, and then we see from there whether there's any response or any counteroffer from the company. But there are instances where I'll send a demand letter out and I won't get a response, or maybe I've noticed over the course of negotiations, things are just getting way too drawn out. There's no response from the company. At a certain point in time, I'm usually saying to my client, we've got to commence a lawsuit. We've got to serve them with papers. If it makes sense financially and there's enough to be gained there, rather than waiting around indefinitely, that's usually the next step, is you've got to serve them with papers. Because once you do that, you're going to put the company under more pressure, and all of a sudden there is an obligation on the company to respond. There are general timelines then that the company has to provide its defense. Whereas before you sue the company, there aren't those same deadlines or guidelines. And so that's one way to sort of try to ensure that you're given the most leverage possible, that you're pushing the matter along. And that's usually what, in these cases anyways, it takes to get a response. So it would depend on how long they haven't responded to the demand letter, depend on maybe how complex the situation was, and that kind of thing, Romy. But otherwise, yeah, there should be a response. And if nothing's happened within a few weeks or a month and you're just sort of still waiting in the wings, then I usually, again, depending on the case and the value of the case, will recommend going the next step and serving them with papers. I'll answer one more question just before I go. It's from Rash, who's saying that they were terminated during their probation after expressing mental exhaustion and their intent to take a vacation due to lack of support. And their contract also promised a mid-probation review, which was never received. Could this be a wrongful dismissal? And what are my entitlements, given that I only received 1 week's worth of pay? So if you're terminated at any time, for that matter, not just during probationary period, but for any time, you can be terminated essentially for any reason the company wants, as long as it's not outright discrimination, usually, which would be a whole problem on its own. The company can let you go. Doesn't have to be the best reason. If somebody comes to an employer and says that they're mentally exhausted and they need to take a vacation, that could be, and the employer lets the person go because, for example, they don't think that this person's going to be the right fit because they're exhausted, after a week or 2 or 3, the employer could be very well within its rights to let that person go. Whether or not there's a potential human rights violation there is debatable. I think you'd have to show that there was an accommodation request, maybe at the behest of your doctor or treatment provider. And following that is when you were let go. Then you could put a bit more pressure on the company, I think, in sort of arguing that there's been a potential human rights violation there. But otherwise, if someone just expresses exhaustion and needing vacation, and the employer says to themselves, we don't want this person here anymore, we're going to let them go, they can do that. And depending on how your contract is worded, if you've signed one, and that's the other question, whether you've signed a contract or that has a probationary period clause in it, it could allow them to let you go within the probationary period and give you nothing, not even just a week, but literally nothing. But if there isn't a probationary period clause, or depending on what it says, even working for a company for a week or 3 weeks could mean you can get a few months of severance. So it'll depend in part on what the contract says. But if there's a good probationary period clause in there and they've let you go because they don't think you're the right fit and there's no accommodation request that's been made, say from a doctor, it could be difficult to prove the human rights violation. And it could generally mean that the employer is within its rights to let you go. And then it's just a question of what the severance owed would be. And that depends on what that probationary period clause says. You said the contract promises a mid-probation review. So I guess it would depend on when exactly that was to occur and when you were let go and what the difference between those two dates are. I don't know if you were let go before the mid-probation review or if you were let go after the mid-probation review could have been should have been provided. So there could be something there in terms of the bad faith argument and arguing maybe there are ulterior reasons for letting you go and they didn't give you a fair shake. So depending on what can kind of be fleshed out there could be a leg you could stand on there. And I would recommend you definitely give us a call and set up a time to chat, just so we can, again, like the others, go through it a bit more detail and sort of cover off every base and make sure at least you know what your options are moving forward. But with that said, and thank you, Rash, for the question, that's going to be my time for the day. Thanks, everyone, for joining. Hopefully, I answered many, if not most, of the questions. And for those I didn't, definitely tune in again. We've got these things going on all the time. We have another live Q&A down below there you see tomorrow with Sefton. So tune in then. But until then, do take care, and I'll be back, I'm sure, soon enough. All the best. Bye for now.